Well, able to access the chat function to send your questions, and you're welcome and encouraged to do so, and we'll be monitoring that chat, and we'll hopefully have some time at the end for your questions and discussion. And as we know, in the tradition of con cases and with an aim of conserving time, I'm going to keep the introductions very, very brief. We are going to start today with a presentation from Gerald Chan, who's a partner at Stockwoods, and will be speaking to us on McGregor and Section 8 of the Charter. We've decided to move sort of chronologically in the life of a case, so we're starting with policing. We'll then turn to Professor Steve Coughlan from Dalhousie University, the Schulich School of Law, who will speak about Zacharias and the exclusion of evidence under 24.2. And then last but not least, of course, we've got Professor Lisa Kerr of Queen's University and Michael Perlin of the Crown Law Office Criminal, who will speak to us on sentencing, Hills and Hilbach in Section 12. So without further ado, I will turn it over to Gerald Chan. And I think Sam will pull up your PowerPoint to get it started.
First, it's the first one up, so we just have to enlarge it.
Or is that my? Oh, I've already failed in my chair duties. There we go.
Thank you so much. It's great to be back at this conference. It's been a few years for me, so thrilled to be participating again. I'm going to talk about McGregor and try to set the table a little bit for that by going back to HAPE and some of the earlier cases. Full disclosure up front, so everyone knows where I'm coming from. I was counsel to one of the interveners, the David Asper Center for Constitutional Rights, that came under some criticism in McGregor, and I will try not to let that criticism inform too much of what I'm going to say. McGregor has really two dimensions to it. In one sense, it's a Section 8 case, and it deals with the plain view doctrine in the context of electronic searches and seizures. But the aspect that I want to talk about is the second aspect of it, which is on this issue of when the Charter, if ever, can apply to extraterritorial state conduct, to the conduct of Canadian state actors outside of our borders. There is a draft paper that we prepared, which is up on the website. Ben Zolf, who's currently doing his LLM at Yale, co-authored the paper with me, and it's called Leaving the Charter at Home, from HAPE to McGregor, which is what I probably should have titled these slides. But HAPE and McGregor really are sort of the two anchor points for this issue, and the Supreme Court of Canada's analysis on when, if ever, the Charter follows the police or other Canadian state actors when they go outside of Canada and then bring evidence back home. Starting point for the court's analysis on this issue, of course, is Section 32 of the Charter, which tells us when the Charter applies. And all Section 32 says is that it applies to the Parliament and Government of Canada in respect of all matters within the authority of Parliament, including all matters relating to the Yukon Territory, Northwest Territories, and then sub B, that it applies to the legislature and government of each province, again, in respect of all matters within the authority of the legislature. And so, in essence, 32 tells us it applies to the Canadian government entities and bodies when they act within their authority. There's no territorial limitation in Section 32, and that makes sense if you think about this, at least to my mind, from first principles, which is that the Charter acts as a restraint on state power when the Canadian government is acting. And so following from that it should therefore, wherever they are seeking to act within their authority, constrain what they are entitled to do. That, of course, is not, as you can probably gather from the tenor of my opening remarks, what the Supreme Court of Canada has said. And the court reached that sort of landmark holding in 2007 in the case of HAPE. But to understand how HAPE came to be and how we then get to McGregor, it's important to understand where the law stood at the time HAPE was decided in 2007. There were three Supreme Court precedents that were governing in this area at the time. Kerr from 95, Terry from 96, and then Cook subsequent to that. Kerr and Terry both deal with police investigations where the state actor that was said to have violated the accused charter rights was that of a foreign government. And here, the U.S. Marshals questioned a Canadian in Cleveland about her boyfriend's recent escape from custody. So the issue was whether 10B was violated. So the state actor were the U.S. Marshals. In Terry, the RCMP sought the help of the Santa Rosa police to effect an arrest in the state of California, but the arresting parties were the Santa Rosa police. So again, not Canadian state actors. And in both of those cases, the Supreme Court did not say that the charter can't apply outside of Canada's borders. What they said was it doesn't apply to a foreign state actor, which seems simple enough, flowing from the language of Section 32 of the charter. Cook was a little bit different. It gets us closer to the crux of the issue that the court then dealt with in Hape and in McGregor, or didn't deal with in McGregor, which I'll come to in a moment. In Cook, the key government actors were Canadian. Cook was arrested by a U.S. Marshal for murder of a taxi driver in Vancouver in response to a Canadian extradition request, but he was then interrogated by Vancouver police while still in New Orleans. Again, the issue was, were Mr. Cook's Section 10B rights infringed? And what the court said in Cook was the charter can apply to Canadian state actors outside of Canada's borders, so long as there would be no objectionable extraterritorial effect. And on the specific facts of Cook, the court did indeed apply the charter, found that there would be no objectionable extraterritorial effect because the American officials in that case took deliberate care not to become involved in the Vancouver police investigation. And the Canadian officers' questioning of Cook did not implicate or interfere with any criminal procedures involving the American authorities. So that's where we're at come 2007 in Hape. And Hape, like Cook, involved conduct by Canadian state actors outside of Canada's borders. The RCMP went to the Turks and Caicos to investigate what else but money laundering, and conducted what we sort of think of as or would term a sneak and peek inside of the Mr. Hape's residence or office, as well as entering the office through a ruse during the day. And so at issue were the Section 8 rights of Hape when the case goes to trial. Governing precedents, Kerr, Terry, and then really most on point being Cook, which says the charter can apply so long as there's no objectionable extraterritorial effect. The parties in Hape argue it on that basis. They don't seek to overturn Cook. The Supreme Court of Canada, however, really of its own initiative, which is somewhat ironic given the approach it later takes in McGregor, does effectively overturn Cook and say that the charter cannot apply extraterritorially to Canadian state conduct, subject to a few limited exceptions, which I'll come to in a moment. And the rationale for the court's holding really was that Canadian law, whether statutory or constitutional, can't be enforced in another state's territory without that state's consent. That would be violation of state sovereignty and our notion of comity. And that where you are seeking to apply the charter to Canadian state conduct in the Turks and Caicos or anywhere outside of Canada, you are engaging not just prescriptive jurisdiction, not simply saying what the rules should be. You're engaging not just adjudicative jurisdiction. You're not just saying we can adjudicate this back in Canada and grant a Canadian remedy, but you are also engaging enforcement jurisdiction, because the charter's guarantees are not simply about granting a remedy after the fact, but about ensuring that Canadian state actors comply with those charter provisions. The court then also adds this rationale of, in the era of transnational crime, it's important that states be able to cooperate with one another and respect each other's legal systems in the course of that cooperation. That's what our notions of comity require. So there's really this sort of harder jurisdiction analysis driving the decision, as well as a slightly softer comity deference analysis. The court in Hape does, however, carve out 3 exceptions. The first is that where the other state consents to the application of the charter to the Canadian state conduct, the charter can apply. The second, and I'll just flesh these out in a little bit more detail after I enumerate them. The second is that where the Canadian state conduct is not only an infringement of a charter provision, but rises to the level or is also an infringement of Canada's international human rights obligations, the charter can apply. The third is that where the admission of evidence back home in Canada, when the police come back home, even though they didn't take the charter with them abroad, when they left, if the admission of the evidence they gathered would be so repugnant or serious as to compromise trial fairness, then a remedy can be granted under Section 7 or 11D in Canada. These were the 3 exceptions in Hape, and I'm going to, I'll just hit on these briefly, but it's fleshed out really more in the paper, suggest that each of these 3 exceptions is deeply problematic. The first because it's illusory, the second and third because they are incompatible with the rationale of the rule in Hape. The consent exception, the court, in fairness, said would be rare, it was intended to be rare. Indeed, in the research for the paper, Ben and I were unable to find a single reported decision where it had succeeded. If you know of one, please let us know so we can amend the paper, which is still in draft. But the idea to the consent exception is that it's not enough that there's a cooperative investigation. It's not enough that the police in the Turks and Caicos say to the Canadian, to the RCMP, well, we're going to work together on this. That's not enough to consent to the charter applying. What the courts have interpreted that to mean is that you have to have someone who has the authority to bind the foreign state. And they grant consent to the application, not just of Canadian statutory law, but the Canadian charter. And that, as you can imagine, is an extremely high threshold that has not been met. So leave that to the side because it's, practically speaking, not really available. You have the international human rights exception. Now, this was applied in the first Omar Khadr case at the Supreme Court of Canada. There, as many of you may recall, Canadian officials go down to Guantanamo Bay where Omar Khadr is being held. The procedures down in Guantanamo had been found by the US Supreme Court to violate the Geneva Conventions, and the Canadian state actors participated in an interrogation down there and collected evidence. And the argument was made that the charter should apply here because there's not just a charter breach, but an international human rights obligations violation, and therefore we should get a charter remedy, which was found to be disclosure. So this exception has been applied. It's not that it's illusory or practically unavailable. The difficulty, I'm going to suggest, with this exception is its incoherence. How can it be that you can get a charter remedy, not for a charter breach per se, but a charter breach that also must be a violation of Canada's human rights obligations? How can it be that the charter doesn't apply, but somehow springs back to life or is revived in some way if the breach is sufficiently serious as to also violate Canada's international human rights obligations? The third, and apologies for going through this quickly, but maybe that's more reason for you to read the paper. The third exception is the trial fairness exception. And again, the difficulty here, I'm going to suggest, is not with its practical unavailability, but with its incoherence. Because if it is not a problematic interference with state sovereignty or comity for a Canadian court to say, you know what, the manner in which you gathered that evidence in the Turks and Caicos or wherever else was so problematic that to admit it back home would offend trial fairness and we have to exclude it. If that's not a problem, then how can it be a problem for state sovereignty and comity for a court to say, you know, you violated Section 8 of the Charter when you were abroad, and we're therefore going to grant a remedy back home in Canada. In both instances, you have a Canadian court examining the conduct of Canadian state actors abroad, measuring it against the guarantees of the Charter, and granting a remedy back home in Canada. And what I would suggest is, if it's fine for Section 7 and 11D, under this notion of trial fairness, it should also be fine under a straightforward Section 8 analysis. Let me just end, because I'm coming to my time, with McGregor. And I really don't need to spend too long on McGregor because the court chose not to decide the issue of the extraterritorial application of the charter. The interveners asked the court to revisit HAPE. It chose not to do so because it said the parties didn't ask us to do so, and the interveners stepped beyond their role in doing so. That's all I'll say about that, considering I was counsel for one of the interveners. But the parties asked the court to decide the consent exception. That was the primary issue in which they said they were litigating the applicability of the charter. The court also didn't decide that. What the court did, or the majority did in McGregor, was to say, we don't have to decide whether the charter applies, and therefore don't have to revisit HAPE. Because if you apply the charter, which we will now do, and they went through a full Section 8 analysis, we find no breach. And what I would say to that is that if that exercise of examining state conduct and measuring it against Section 8 of the Charter, which is in fact what the court did, even if it was in obiter, did not offend state sovereignty or comity in the way that HAPE contemplates, then really the core rationale for HAPE should fall away. And so McGregor, in my respectful view, was a missed opportunity to revisit and correct this deeply problematic precedent, and hopefully won't be another 16 years before this issue goes back to the court. And when it does, if you are counsel for the parties, please raise. Thank you.
Thank you, Gerald. That was terrific. I think resonated with some of Kate Glover-Berger's comments in the opening plenary about just the court's posture towards revisiting its own jurisprudence or responding to scholarly critique, and a wonderful critical analysis of the decision, and also a great primer for those who haven't read it. It gives a lot of rich context and background, so thank you. Let me turn things over now to Professor Steve Coughlan, and I will try to launch your PowerPoint this time. Let me see how I do.
Okay, thanks, Palma, and thank you to the organizers for inviting me back. So I am speaking about the Zacharias decision from the Supreme Court of Canada, and actually Ben keeps saying that we're going to talk about Section 24.2, and I mean, I'll get to that maybe, but I actually think that it's other parts of the decision that are more interesting than Section 24.2. But then another thing that I think is that very few things are not made better by the presence of jelly beans. So I brought some. Now, you're probably all familiar with this kind of game, right? Of like, guess how many jelly beans there are in the jar. But what I want to suggest to you is that there are actually two different games you could play here. Take your best guess as to how many jelly beans there are. The winner is the one who's closest without going over. But now, guess how many jelly beans there are in the jar. The winner is the one who's closest without going under. My guess is that you'd come up with different numbers if you were guessing from that way. And the point there is that even when you're trying to get something right, the direction you come at it from makes a difference. And that's what I think is the issue here in Zacharias. It's a matter of perspective. It's a question of what direction do we come at the issue of the right balance between police powers and individual rights from. Because if we come at it from one direction or the other, we're likely to end up in a different place. Sometimes, and this is a thing we can see over easily 40 years of Supreme Court of Canada decisions, sometimes in the context of police powers, courts are asking themselves, what are private individuals entitled to expect from the police? But sometimes decisions are based on the reasoning, how much is it reasonable of us to ask of the police as they exercise their powers? And so that, particularly in the context of arrest, which is where Zacharias arises, is an attitude that has been reflected for a long time, both perspectives. So the Story decision from 1990, for example, is talking about the fact that police have to obtain a warrant. When they're arresting with a warrant, they have to show that they have reasonable and probable grounds. But Story says that when it's an arrest without a warrant, it's even more important to be sure that those reasonable and probable grounds existed, right? Like that's coming at it from the point of view of the individual. We don't have a judicial actor in between assessing, so we're going to say, well, that makes it even more important. On the other hand, exactly the opposite has also been reflected in Supreme Court of Canada decisions. Beaver, just 2022. Judicial reflection is not a luxury the officer can afford. It's not reasonable to ask of the officer that they exert that level of control. So we actually get both of these attitudes. Zacharias, to me, is fundamentally about which of these perspectives is the right one, both which is the right one in the context of an arrest, which is the primary issue, but also in the context of Section 24(2). And I don't think that Zacharias settles it by any means, both because it can't be settled, but also because Zacharias just doesn't settle it. Now, it is important in Zacharias to be clear on the facts of the case here. So he was stopped for a motor vehicle infraction, and that was perfectly lawful as a traffic stop. During that traffic stop, they conducted a sniffer dog search, but they didn't have reasonable suspicion. So the sniffer dog search was unlawful. On the other hand, the sniffer dog search did turn up evidence of possession of narcotics, so they arrested him for possession. Now, if the sniffer dog search results add to reasonable grounds, that was a lawful arrest. But if the sniffer dog results don't add to reasonable grounds, it was an unlawful arrest. Based on the arrest for possession, they conduct a search incident to arrest. They find a bunch of cocaine. That search, well, it was lawful if the arrest was lawful, but it was unlawful if the arrest wasn't lawful. And, in fact, having found that much cocaine, they arrested him not just for possession, but for trafficking, which again was lawful if the search incident to arrest was lawful, but unlawful if it wasn't. And, in fact, back at the station, they arrest him once again on a proceeds of crime charge. So there are even two subsequent arrests that arise. So we've got one clear violation, which is the sniffer dog search. And then the question becomes, well, was the first arrest unlawful or not? Was the search incident to arrest unlawful or not? Were the arrests based on the search incident to arrest unlawful or not? One of the great luxuries that like academics have, as opposed to like people like Gerald who actually do this stuff, is that we don't have to care about what happened to the real person. So obviously from Zacharias' point of view, the issue is, do I get convicted or not? But, you know, with the luxury of academia, the issues are, can unlawfully obtained evidence form part of the reasonable grounds for an arrest without a warrant, which is a point that actually lots of courts of appeal had addressed prior to Zacharias without agreement, but most actually saying no. And then secondly, how do consequential charter breaches affect the exclusion analysis? Should we think in this kind of case where we have one definitely unlawful search, the sniffer dog search, but then maybe two unlawful arrests and three unlawful arrests and one unlawful search, all of which are consequent on the first one, how, if in any way at all, do they factor into the Section 24(2) analysis? So what I want to say here is a couple of things. First is that although these are different issues, the key point of whose perspective we come at this from is crucial to deciding both of them. The second thing I want to say is that Zacharias didn't really decide the second one, or at least on my view, it didn't decide the second one at all. We have to look at the cohorts here for the decisions, because it's only 5 judges Well, we got 3 decisions and everybody wrote, right? Like nobody has simply concurred with somebody. Justices Rowe and Obansewin found that unlawfully obtained evidence cannot add to reasonable grounds. So the arrests would be unlawful. But they found that the consequential breaches, once we're into the Section 24.2 analysis, don't have any effect on the seriousness of the breach. We can't say that the breach was more serious because of it. On the other hand, Justices Martin and Casserer, well, they also say that unlawfully obtained evidence can't add to the reasonable grounds, but they think consequential breaches do affect the seriousness of the breach. So we've got a 2-2 split so far. You'll never guess who the 5th judge is. It is, of course, Justice Cote, the great dissenter, who dissents. Concluding that unlawfully obtained evidence can add to reasonable grounds, which in her view means there is no charter breach to assess in Section 24.2, which means she actually doesn't decide the second issue that the other 2 cohorts split 2-2 on. So where we're left on this, on these issues, can unlawfully obtained evidence form part of the reasonable grounds for an arrest without a warrant? Okay, we're pretty good on that. No, 4-1, we've got a 4-1 decision. They cannot enter into reasonable grounds. But on the issue of whether, of how the consequential breaches affect the 24.2 analysis, to flesh this out a little bit more, all 4 of the non-dissenters agree that it affects the impact on the accused's charter protected interests. Having been arrested a couple more times, having been searched once more, definitely in that 3-part charter analysis where the second thing to consider is the impact on the accused's charter protected interests, all 4 of them agree, yes, we're going to have a greater impact, so it's going to weigh more towards exclusion that way. But on the other issue, was the breach more serious? I don't think I have an especially heavy thumb. As I say, that they all affect charter protected interests, 4-1 or 4-0, right? Because Cote doesn't really address this at all. But on the issue of whether consequential breaches affect the seriousness of the breach, well, only 4 of them talk about it. 2 of them say yes, 2 of them say no. Justice Cote concurs that there's no exclusion of evidence. She seems sort of vaguely sympathetic to the no, so maybe it's 2 + 1 to 2, but really, it's just 2 to 2. Now, I will say, what this means is that on a careful reading of the case, the point hasn't been settled. Supreme Court of Canada decisions are frequently not read carefully, right? And Rowe and Obansewin wrote the majority decision because they're the ones who say we're not going to exclude, and Justice Cote agrees with that because she found no additional breach. So I think it's likely that people will read Justices Rowe and Obansewin's decision as the majority reasoning, but that's actually just not correct. On this particular point of whether consequential breaches affect the seriousness, that's still a 2-2 split. So let's look a little bit here at the, let's not look at the reasoning. I've got like 30 seconds left. We won't run through the reasoning on why it can or can't add to reasonable grounds, other than that I want to say that's clearly a matter of perspective, right? Like the majority in saying that it can affect that, they obviously are looking at it from the point of view of the individual, right? Police will know and comply with the law. Police shouldn't be able to rely on their own misconduct. Whereas Justice Cote, thinking that it should still be entering into reasonable grounds, is making the same Beaver kind of point. The law does not expect the same kind of inquiry of a police officer that it demands of a justice faced with an application. So she's looking at it from the point of view of the police. The majority looked at it from the point of view of the individual. I want to say that it's that same thing going on in whether it adds to the seriousness of the breach. And I'll just jump to my last slide here. Justices Rowe and Obonsuwan say that it's not more serious on this basis, where the police honestly believe they've not committed an initial breach. It's not more serious. So it's not more serious because the police don't think it's more serious. On the other hand, Justices Martin and Casserer are looking at it from the perspective of the individual whose rights have been violated. Conduct that does not deliberately violate the Charter may nonetheless undermine the public's confidence in the administration of justice. So it seems to me that, first of all, this issue still has to be settled. It's settled that it can't enter into reasonable grounds. It's settled that it makes the impact greater. Unsettled whether it makes it more serious or not. I'm inclined to the Martin and Casserer position on this, but to be perfectly honest, I've still got to work this out in my head. I'm not 100% sure on that, but that's the way I'm leaning right now. Anyway, I'm going to stop there, and maybe we'll have the bids later on for the jelly bean. Thank you.
Thank you. Thank you for that very cogent analysis of the case and for the jelly beans, which are a pedagogical masterstroke. It reminded me of watching The Price is Right as a kid, where someone would be asked, how much is this snowblower? And they'd be yelling, $1, $1. So I will now forever think of that in relation to the case. We now have, speaking of pedagogical mastery, we have Professor Lisa Kerr up to begin our presentation. She'll speak first, followed by Michael Perlin on, here we go, section 12 of the Charter, where we are now.
Thank you, Palma. Well, I'm very pleased to be here to talk about the Section 12 cases this year, which dealt with mandatory minimums. And I'm really happy to share the task with Michael. He has been counsel on cases like Hilbach and Boudreau, and he really brings so much expertise to this area. So I'm going to focus on Hills and Hilbach. Now, both of these came from Alberta, and the Alberta Court of Appeal upheld the penalty in Hills and struck the penalty in Hilbach. And in doing so, they managed to get both wrong. The Supreme Court struck the penalty in Hills and upheld the penalty in Hilbach. So Hills deals with a 4-year mandatory for discharging a firearm into or at a place, knowing that or being reckless about whether a person could be there. Justice Martin writes the majority opinions in both of these cases, and her decision in Hills considers 2 reasonable hypotheticals. Those are both at the bullets on the slide. And what she says is that a fit sentence for those 2 scenarios would be a suspended sentence with 1-year probation. And she concludes that 4 years is grossly disproportionate to that. Hilbach deals with a 5-year penalty for a first offense of robbery committed with the use of a restricted or prohibited firearm. There was a related case of robbery with just a firearm. I'm not going to deal with that, and it has been subsequently repealed, that provision. So Hilbach is not argued on the basis of a reasonable hypothetical. This is looking at the offender before the court. And what the majority says is that a fit sentence for Mr. Hilbach would have been 3 years, but 5 years is not grossly disproportionate to that. And Hilbach is really interesting. This is the first mandatory that the court has upheld since, I think, Ferguson in 2008. And it's a bit striking that it would happen in this context. It's the first one over all these years where the focus is on the offender instead of a reasonable hypothetical. And it's the first case that deals squarely with the relationship between Gladue and Section 12. So Mr. Hilbach is a young Indigenous man with strong Gladue factors. He's abandoned by his parents as an infant. He's raised by grandparents who both attended residential school. His youth was marked by poverty, physical abuse, and addiction. He does the robbery in order to get some cash together to get back to his reserve. Now, at the time of sentencing, he's working in construction, he's doing better, he's taken some positive steps to get past a history with gang affiliation, and he has a daughter who is 18 months old. He's also only 19 at the time of the offense, and there's a lot of discussion in the cases this year about youth and how severe federal imprisonment is for younger offenders. So it's a bit striking. This would be the first mandatory the court upholds in 16 years, but we'll certainly talk about why it happens. So I have 5 key takeaways from these cases. I'm going to be very brief with the first 2. I know Michael will touch on those, and the last 3 are very interrelated. So starting with the question of justifying the reasonable hypothetical. This is a perennial question in this area about the legitimacy of this device. It's really been the most controversial part of Section 12. Both Justices O'Farrell and Wakeling are highly critical of it in the court below, and they're really not alone. And Justice Martin says that she's going to try to lay some of this debate to rest in Hills. And what she says is that this device is legitimate for these 3 reasons that I have laid out in the slide. And what I want to say about this part is that these reasons are not new. And to date, they really haven't laid the controversy to rest. And I think that's because I just don't see that these reasons really fully answer the question of why we can't just wait until a mandatory actually produces an unconstitutional sentence for a person before the court. So my point here is just that I see this as a bit of a lost opportunity, and I do think there are better or more justifications for the use of this device. But I think they're particular to the Section 12 criminal law context. I just wish the court would say more on this, and I'll just give one example. I think there are others. One thing the court could do would be to explain how mandatories can impact the plea bargaining context. So in that context, you can have a potentially unconstitutional mandatory that's on the books that causes an accused person to plead guilty to another offense that doesn't attract the mandatory. And so in that way, the mandatory could be affecting outcomes in a way that is not only insulated from review, but actually invisible to the formal legal outcome in the case. So I just wish the court would say more about these institutional dynamics that I think would explain better why leaving these laws on the books it can be affecting outcomes in real ways. And that pitch was before them in an intervener brief in Hilbach, but they declined to take that up. Constructing the reasonable hypothetical. There's been a chronic debate in this area around whether you can include personal characteristics, sort of the circumstances of the offender type stuff, as part of the hypo. And Hills affirms what had been clear in Kerr. Factors like age, poverty, race, indigeneity, mental health issues, addiction, these can all be part of how the hypothetical is constructed. We are seeing a lot of creativity in this area from counsel, and I know Michael's going to say a lot more about what that should look like going forward. So one of these personal characteristics that can matter a lot to the Section 12 analysis is youth. And in both Hills and Bertrand Marchand, there are important passages about youth as mitigating, about the impact of custody on young people, specific dangers in the prisoner environment to them. And I think these concerns could be really important for a case that's going to be heard this year called IM, around when judges can sentence young people as adults under the YCJA. All right. So Hilbach contains the first meaningful discussion we've had from the court about the place of Gladue in the Section 12 analysis. And the decision makes clear Indigenous status can matter in 2 distinct ways. First, in terms of the moral blameworthiness associated with the offense. That's sort of a standard Gladue analysis. The second dimension I think is interesting, and I think it's really important to understand how this is separate from moral blameworthiness. Justice Martin talks about how Indigenous inmates are more severely affected by imprisonment. She cites OCI reports for the data on that. Add to this that the trial judge in Hilbach had been really concerned in this case about the impact of a 5-year federal sentence. The trial judge thought this would undermine any hope of rehabilitation for this guy. In effect, thought the sentence would be criminogenic for him and that those effects would last beyond 5 years. And it's interesting, Justice Martin agrees with all of that. She says the severe impact of incarceration on an Indigenous offender properly carries significant weight. Now, I think that's useful, and I expect good defense counsel will make use of that in the Section 12 context and sentencing law generally. The question we have to ask is whether Justice Martin's ultimate decision is consistent with that direction. Another takeaway is more broadly about the effects of imprisonment. And this, for me, is a really interesting part of Hills. Hills says that the likely effects of imprisonment have to be factored into the analysis. What Justice Martin seems to be saying here is that proportionality is not just a matter of duration, that there will be qualitative variation in the experience of incarceration, and that this will affect the severity of any sentence as it's delivered on the ground. And she names the possible drivers of penal variation by naming these three vulnerable groups of inmates who will do harder time. Police officers, perhaps a good idea rhetorically to start there. People with disabilities, and people who will face discrimination in the institution. So again, I think this is very useful in terms of unpacking what proportionality means, what has to be part of the calculation of a fit sentence in Section 12 and sentencing law more generally. But again, we have to ask whether this direction is compatible with the result in Hills. So this brings me to my last topic. I want to end with the question of why Justice Martin upholds the mandatory in Hilbach. And the main thing to say here is that she upholds it because of the seriousness of the offense in terms of both the act and mental element. This is robbery with a prohibited or restricted firearm. It requires using violence or a threat of violence in order to steal, and it requires using the firearm in order to facilitate the offense. Justice Martin distinguishes cases like Smith, Kerr, and Lloyd, all cases where mandatories are struck down. Now, those cases involved drug importing, firearm possession, and trafficking. And for each of those, it was, of course, possible for the offense to be committed in a very serious way, but it was also possible for it to be committed in a very unserious way. That is not the case for the offense at issue in Hilbach, Justice Martin concludes. Though I'll note that Justices Jamal and Kerr in dissent emphasize, among other things, that this firearm was unloaded. And what they're suggesting is that there is a spectrum of blameworthiness, even for this offense, and this was at the lower end. Now remember, even Justice Martin doesn't think 5 years, the 5-year mandatory, is a fit sentence. The fit sentence, she says, for this young Indigenous person who will be very negatively impacted by imprisonment is actually 3 years. The question for Section 12 purposes then becomes, is the gap between 3 and 5 grossly disproportionate? And Justice Martin answers no to that question. And part of why I think she's willing to tolerate the gap relates to her suggestion that mandatories are most vulnerable when they replace probation with jail. So the idea here is that Hilbach is headed to federal penitentiary even without the mandatory. And that's different, she says, than a case like Lloyd. There, the mandatory was only 1 year, but it replaced probation with jail. So the temporal gap is less in Lloyd than in Hilbach, but the qualitative gap is vast. So it's clear then that actually part of what drives this outcome is actually Justice Martin's attentiveness to the qualitative conditions of criminal penalties. So what do I think about that? And this will be my last set of thoughts. So I think Justice Martin is absolutely right to suggest that mandatories that require custody in cases where custody would not otherwise be imposed are the most troubling, right? They should be understood as the most vulnerable. They are most likely to shock the conscience. What seems maybe more questionable in this reasoning, though, is the idea that there's little significant difference between 3 and 5 years simply because both entail multiple years in federal penitentiary. And I think it's quite hard to square this conclusion with Justice Martin's appreciation of the severe impacts of incarceration for an Indigenous youthful offender. It seems as if she pays attention to the qualitative similarities of a 3 and 5 year sentence, but she loses track of other qualitative dimensions of the penalty, what additional years in custody in your mid-20s can mean. separation from a young child, the inability to pursue educational or vocational training, vulnerability to the dynamics of the prisoner society, the risks of gang involvement that could wind up being permanent. All of which were made more severe and are made much worse by imposing the mandatory rather than the fit sentence. Thank you.
Good morning, everyone. Good afternoon, everyone. Thanks very much to the organizers and to Palma for having me here. It's great to be here. I think, so Lisa selected this slide for a PowerPoint presentation, and I'm not sure if this is indicating that the first half of the presentation is organized, clearly structured, and then we're moving into a period of chaos. But I hope for your sakes that that's not the case. So I'm going to provide 3 more points on Hills, Hilbach, and Bertrand Marchand, the 3 cases that the Supreme Court considered on Section 12 this year. The first being comment on the debate on whether the Hills factors contribute something useful to the analysis. Some further discussion on the reasonable hypotheticals, the approach as it's evolved in Hills and Hilbach, and particularly how detailed those hypotheticals should be. And then if we have time at the end, I'll talk about an interesting paragraph at the conclusion of Hilbach and the question it raises on whether the court has the power to stay the service of a mandatory minimum sentence. So first, the debate on whether the Hills factors contribute something useful to the analysis. So as you likely know, the test under Section 12 requires you to first set the fit sentence for the accused person and the fit sentence for any hypotheticals that are under consideration. And then you have to ask under the second stage of the analysis whether the mandatory minimum sentence is grossly disproportionate to the fit sentence identified under the first stage. And Justice Barton, for the majority, explains that deciding whether a sentence is grossly disproportionate requires the court to consider 3 factors. First, the scope and reach of the offense. Second, the effects of the penalty on the offender. And third, the penalty, including the balance struck by its objectives. And that last one is a little bit amorphous, but I think what they're getting at, just by reading the application of the test, is the relationship between the penalty, the offender before the court, the hypotheticals, and the relevant sentencing objectives in the case. So in dissent, Justice Cote says that each of these considerations is relevant to determining a fit and proportionate sentence at stage 1 of the analysis, but they don't really tell us anything at the second stage of whether the sentence that's required by law is grossly disproportionate. And I think she has a point there. In deciding what a fit sentence is for the offender before the court in the hypothetical, you're going to consider the scope of the conduct captured by the provision. That's really what you're doing. That's the purpose of the reasonable hypothetical, to identify the scope and the lowest end of the range. And you're going to look at the impact of the punishment on the offender. That's relevant to determining what punishment is fit. And then you're also going to consider the relevant sentencing objectives. So I think she has a point, but I do think it is good for the Supreme Court to try to provide a little bit more structure in the analysis. And in particular, the court is focusing the first factor. Oh, thanks. And focusing the first factor on scope, the court is drawing everyone's attention to what is proven to be the most important factor in distinguishing constitutional laws from unconstitutional ones under Section 12. It's usually determinative on whether a provision will be struck down. And ultimately, though, the efforts to provide more help in the analysis is helpful in guiding thinking, but I don't think it provides anything close to a bright line rule, and obviously that would be ideal, but I don't think we're going to get it under Section 12. So Justice Martin says that when comparing 2 sentences of imprisonment, there will be a continuum between exact fit and gross disproportion, and a judge not only has the authority to make such a determination, but is recognized as being well placed to do so. The judge must engage in normative reasoning and make a judgment call. So at the end of the day, gross disproportionality to a certain extent is in the eye of the beholder. So the next point I'd like to talk about is how detailed should hypotheticals be. The Supreme Court was faced with two primary arguments on this issue. The first from the judges in the Alberta Court of Appeal, suggesting that the court should completely abandon the use of reasonable hypotheticals. And Justice Martin held this proposal runs counter to the jurisprudence of this court and lacks merit. So they were not going to go there. Some of the parties and interveners suggested that the court should provide more guidance on when mitigating personal characteristics can be used in the analysis. And I was involved in the case as counsel for Ontario. We argued that personal characteristics can be relevant and used in the analysis to the extent that they assist in distinguishing one law from another, good law from bad. So a personal characteristic that's relevant to the scope of the offense or the way that the punishment affects an individual would be relevant, but others would not. And the court holds that personal characteristics can be used unless they make the hypothetical unreasonable. So what does that mean? How detailed should hypotheticals be? You see, there's two approaches in the jurisprudence that we've observed and that are often argued in cases. We've got the stick figure approach, and that's something that's commonly argued. You see that in Smith, a very simple hypothetical like an accused person crossing the border, a young person with their first joint of grass, or more recently in the Court of Appeal decision in BJT, you have really one sentence sketches of the conduct at issue. At the other end of the spectrum, you'll see hypotheticals that are much more detailed, like this one that was used by Mr. Zwodeski, one of the respondents in Hilbach, who referred to Eric, a licensed firearm owner, who's an 18-year-old student in grade 12 at a high school in small town Alberta. His teachers describe him as a nice kid, but not the brightest bloom in the canola patch. He lives on a farm with his parents. He and his friends are out hunting, and it goes on from there. But there is a lot of color there, and we're closer to that beautiful Caravaggio painting. So what does the Supreme Court say? They say that the fully rendered scenario in the Zwodeski factum is probably too far. Courts should be wary of detailed scenarios that stack mitigating factors, combined with an interpretation that stretches and strains the technical meaning of the offense, like certain of Mr. Zwodeski's hypotheticals in the companion appeal to this case. But ultimately, the court arrived at something between the stick figure and the Caravaggio, but closer to the Caravaggio, I would say, best represented by this Cézanne painting. And you see that in the court's first opportunity to apply the analysis later in 2023 in Bertrand Marchand. That case considered the mandatory minimum sentences for child luring. And the first hypothetical that Justice Martin provided was the representative offender is a first-year high school teacher in her late 20s with no criminal record. The offender has been diagnosed with bipolar disorder. One evening, she texts her 15-year-old student to inquire about a school assignment. Feeling manic, she directs the conversation from casual to sexual. The two meet that same evening in a private location where they both participate in sexual touching. The offender does not engage inappropriately with the student, other than the sexual touching, I guess, or on any further occasions. The offender pleads guilty and expresses remorse at sentencing. So I think we're probably quite a bit closer to the Caravaggio than to the stick figures. And there's another example that the court relied on in Bertrand Marchand. So my theory about this is that there has been a change in the approach to personal characteristics, and it reflects a change in the way that reasonable hypotheticals are being used in the Section 12 analysis. So if you go back to Noor, there's various dicta in the majority judgment of Chief Justice McLaughlin that hint at the purpose of reasonable hypotheticals. They're meant to show the scope of the law, the sort of situations captured, the minimum conduct, the kind of conduct and situations caught by the law. And I think this is about scope. It's about identifying whether the punishment is really broad and it's meant to apply to a narrower band of conduct and therefore overcaptures and applies the punishment to too broad scope of conduct. The methodology that they propose is to identify the scenario and ask simply whether the mandatory minimum is grossly disproportionate. It would be abhorrent or intolerable or would shock the conscience. And in an application in Noor, the court simply says a 3-year term of imprisonment for this reasonable hypothetical would be grossly disproportionate. And at the conclusion of that analysis, the court indicates that personal characteristics cannot be entirely excluded. There is some use for them, but it's not a broad one. That's what I would take from that comment. Now in Hills, the purpose has changed. The court now identifies the lowest fit sentence that is reasonably foreseeable for the offense provision to identify possible gross disproportionality. It's really like the analysis has just turned a little bit from focusing on the conduct or the effect of the punishment to really being explicitly about sentencing. And the methodology is to determine the fit sentence as precisely as possible for the hypothetical and ask whether the mandatory minimum is grossly disproportionate. And the example that they use, that they fix a sentence. They say a suspended sentence of up to 12 months probation would be appropriate, and then say the mandatory minimum replaces a probationary sentence with a jail sentence, and that is what weighs in favor of a finding of unconstitutionality. And the court's conception of personal characteristics then has changed from they cannot be entirely excluded to determining a proportionate sentence, quote, requires a consideration of the offender's personal circumstances, which includes their personal characteristics. And that only makes sense if you're actually sentencing or purporting to sentence this hypothetical person, you have to consider mitigating factors because you can't complete the sentencing analysis without doing so. So the last point that I make on this is that there are a few takeaways for litigants following Hills. And I think it's fair to say that following the Supreme Court's approach in Hills and Hilbach, everybody should be interested in conducting the reasonable hypothetical analysis. I know Lisa mentioned that Hilbach argued the case based on his own facts. Mr. Hilbach did. But it's clearly in the defense interest to argue these reasonable hypotheticals and come up with as mitigating a scenario as possible because it improves the likelihood of success. For the court, the analysis just isn't complete without considering reasonable hypotheticals because the purpose now is to look at identifying the lowest reasonably possible sentence that the provision can result in. And then for the Crown, there's an interest in conducting this complete analysis too, and in identifying a reasonable collection of mitigating factors, because again, without considering those hypotheticals, the analysis is incomplete. So I'm gonna skip over the last point and hopefully it wasn't too chaotic for you.
Not at all chaotic. That was terrific. And thank you to both Michael and Lisa and to all of the presenters. And we've conserved 10 minutes for questions and discussion. And I have Professor Berger assisting and Professor François Tanguay-Renaud starting us off.
Great. 2 questions, one for Gerald, one for Steve. Gerald, you pointed out that the Section 8 reasoning in McGregor is obiter. Now, in this obiter is probably the clearest statement of the plain view doctrine that we have from the Supreme Court, and it's also the adoption of Jones, 2011 Ontario Court of Appeal case, which says if in the context of a legal search, the police of a computer, the police stumble upon a file that shows evidence of some other crime, then they can seize that, as it were. That seems to go against the trend in the Supreme Court to extend privacy in the digital context, right? So Bajkovets and the cases that have just been released. So what to make of that, right? The fact that it's obiter could allow us to just say, well, that's Justice Cote. She's dissenting in Bajkovets, so let's just ignore this. But at the same time, it's a unanimous decision. Steve, I really like the perspectival kind of comparison. We know that under Section 24.2, the Supreme Court has said that deterrence is not an objective of our exclusionary rule, unlike under the Fourth Amendment. Is it your view that one part of the court actually thinks deterrence is an issue, and that accounts for that perspective, which is, protecting the rights of the accused and basically telling the police what to do and trying to hold them at bay? Are they trying to feed that through the back door, as it were? Is that something that might account for this?
So much as I would like to ignore that plain view analysis on the basis that the court never actually settled whether the charter applied and therefore it's obiter. I mean, it's obiter from a majority of the Supreme Court of Canada in an area of the law that I think, at least in Ontario, as you point out, most courts had been following that approach since Jones was decided by the Court of Appeal. The plain view doctrine in the digital search context and the computer search context, I think, is hugely concerning because of its potential to reach well beyond its intended scope. It's premised on this idea that if you are in the course of searching a computer for evidence, let's say, of offense A, whether it's child pornography or voyeurism or whatever the offense is that's authorized in the warrant, then as long as you're in the course of doing that, then whatever you stumble upon, even if it's evidence of offense B, you can seize, which sounds fine in principle, in theory. The problem is that once the police are in the device, they're almost always, unless they are subject to searing cross-examination by skillful counsel. I'm looking at Chris Rudnicki. They're almost always going to be able to say, well, we were searching, every part of the computer for evidence of child pornography, and scrutiny under. You can try to attack it on manner of search, that it wasn't a reasonable manner of search to search every nook and cranny of the device if you really were concerned about only the evidence authorized in the warrant. But those are challenges. Those challenges have not been particularly successful. So I think the application of the plain view doctrine in this context does have quite a bit of potential to expand what the police can do beyond the application of the plain view in sort of physical world searches.
We've got one question from our remote viewers, and then Ben. Oh, I'm sorry, Steve. Jumping ahead.
Yeah. So the deterrence point has occurred to me. As I say, I'm sort of still thinking through my reasoning on it here. And I don't think it's quite as explicit as that, but I do agree with you that I think it is like pulling in that direction, because of course, the 24.2 analysis is all meant to be about the administration of justice not being brought into disrepute, as opposed to deterring police behavior, and I agree on your point there. But the grant analysis kind of has, the first two factors, which are from the individual's perspective, and then the third one, society's interest on the adjudication of the merits, which kind of pulls the opposite way already. And my concern is that saying that the consequential breaches don't affect seriousness kind of shifts that balance. You've kind of got two that are from the individual perspective and one that isn't. And well, now one of those two that was from the individual perspective isn't anymore, which is moving more in the direction of, are we just trying to punish the police, which, as you say, is not the point of 24.2. So yeah, I do worry about that aspect of it.
Thank you, and apologies again. We have one remote question, and I know Deborah has a question as well, and another. Oh goodness, we're going to be tight on time. Okay, we'll do our best here. The question I have from a remote audience is for Michael and Lisa, which is, how do you see these recent cases, Hills, Hilbach, Bertrand Marchand's, impacting Section 12 litigation outside the mandatory minimum sphere? For example, arguments that carceral conditions violate Section 12.
I mean, I think with I think with the Bissonnette decision, we sort of know that there are different questions raised by a mandatory minimum versus a prison conditions case. Bissonnette talks about conditions that would be incompatible with human dignity, violating Section 12. So I think we actually are clear now that a mandatory minimum is a particular analysis and prison conditions is a different track or different prong, as the court said, of Section 12, so.
I think we had a question in the back.
Can I just add?
Oh, of course. I'm gonna back away from the mic.
So could I, if I could just add on to that, that I think what we see in these cases is the court, maybe for the first time, explicitly saying, this is the test just for mandatory minimums. And I don't know if we've seen that before. And I think what we see in some of the Hills analysis is taking the analysis from Bissonnette and importing that into the grossly disproportionate mandatory minimum analysis.
We'll go to Deb next.
Okay, I'll be quick, and I'm sorry if I jumped in, but it does follow directly on this. And the preoccupation I currently have, so Deborah Parks, I'm at UBC, and is around life sentences right now. People know this, who know me, and particularly looking at youth, life sentences for youth. And the interesting thing about that is that it, to my mind, combines both tracks, because for getting a life sentence for a young person is discretionary whether the judge will have an adult sentence or a youth sentence. But then once they're into adult sentence, it's mandatory life for murder. That's what I'm looking at. And so I'm just interested in your thoughts on kind of where we are, what Hills and Hilbach do, if anything, for that kind of a challenge. And particularly, I'm interested in also, so adding the youth question and also party liability, particularly for what I think is the most problematic mandatory sentence, which is life, and how in the Hills and Hilbach cases, they do start talking a bit about party liability in the hypotheticals, to my mind, for the first time. And I'm just wondering how you think about that in the context of life sentences and the youth question in particular.
Maybe I'll address the first part and leave party liability to Michael if he doesn't mind. I think what's important in these cases for youth is there is that distinct treatment of reduced culpability. That's one sort of ground for mitigating a sentence against a young person. And the second is the recognition of the effects of imprisonment and how hard life is in the prisoner society and the particular risks that they face there. And I agree with Michael, it's a neat point that Bissonnette sort of makes crystal clear mandatory minimums is this one track of Section 12, but then we see the second track sort of get imported over to the mandatory minimum context with these Hills factors that tells judges to think about effects of imprisonment. So yeah, I think I fully expect those passages or those portions of this case to be really important, of these cases to be really important, and I am, yeah, for those reasons.
And then on the party liability question, I think it arose in those cases because it was featured in some of the hypotheticals that were argued. And I think you're right. I don't know if I've seen too many cases where we start exploring and expanding upon the principal offender and start looking at whether the hypothetical or the mandatory minimum would be unconstitutional for somebody who's a secondary party. The first reaction that I have to that is that I think what you'd probably see in response to those arguments, if I were the Crown who was providing a response, would be to hearken back to Brown from the Supreme Court, where it was an early mandatory minimum case where the Crown limited its defense to a particular statutory route in the provision. So the court upheld a provision because the Crown was focused on just the manner in which the offense was committed, that manner that was before the court, and declined to consider hypotheticals that engaged other statutory routes to liability. But I don't know if I don't know if the Supreme Court today would continue to follow that approach or not.
It does seem to be absolutely the case. I mean, sentencing, you're allowed to look at the degree of participation, the degree of responsibility, and you cannot do that with a mandatory for an accessory. So yeah, it's really interesting.
I think we have one final question from a patient colleague in the back.
Yeah, so I'll try to be quick. Monica Basso, licensed paralegal, LifeWorks. just with considering Zacharias and considering, consequential breaches and whether they add to the seriousness, the panel had touched on previously, not punishing police conduct, but are we going the opposite direction where, as we indicated in Zacharias, that there was a minimally intrusive initial breach, being the sniffer dog breach, and that could be a shield for conduct, and whether that's being operated more like a sword for public policy considerations as opposed to having every breach evaluated on its merits.
Yeah, I mean, that goes to the core of the consequential thing. I'm struggling with the certain level of skepticism I have here, which kind of goes back to Francois's first question and Gerald's point about there just seem to be so many police officers out there who are not trying to think, what is the proper balance between state powers and individual rights, and are rather thinking, what tools do I have in my toolkit, right? And who are searching the computer because here's the way to do it, or who are stopping the car because here's the way to do it. And they've got a goal in mind and they're using the mechanisms that are available. So to the extent that we see that as undesirable, and I think that should be completely, I think the Zacharias decision is moving in the right direction in saying, yeah, actually you cannot use those unlawfully obtained grounds to enter into your reasonable grounds for later things. That does kind of run against 489 sub 2, unless maybe it doesn't, because 489(2) requires that you were lawfully doing what you were doing, actually. So come to think of it, Zacharias is perfectly consistent with that approach.
Well, thank you for that. We are, I think, at the lunch hour now, and so I want to just thank once again our panelists and all of you for this excellent discussion. Thank you, everyone.
Just in terms of wayfinding for the lunch, we have a half hour of have at it and sit and enjoy. We're then going to be assembling in the large room for our Laskin lecturer, Deborah. So if you're not finished, I think it's understood. Please feel free to bring your lunch in. But we do want to meet back at 1:15 in the large room. Again, thanks everyone so much.